Good morning, everyone. The 14th District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. The court will call the case of the state of Michigan versus Marcia Norman, case number 24S0002, as well as 23W001843.
Good morning. If you're Rachel McDuffie for the people.
Paul Barnett on behalf of the township.
Hi, good morning, Your Honor.
Good morning. Please state your name for me.
Marcia Norman.
Thank you. Who's representing Ms. Norman from the PD's office, please?
Sorry. Go ahead, Allison.
Okay, sorry, Your Honor. Assistant Public Defender Allison Mueller here on behalf of Ms. Norman.
Thank you. We're here for a pretrial and a show cause today.
Your Honor, regarding the pretrial, we will be asking for an adjournment. I believe the plan is for Ms. Norman to complete an assessment.
No objection to the adjournment, Ms. Mueller. As I've advised before, assessments prior to negotiations don't have any effect except that they usually make things worse. In this case, her offer would be impaired as long as there aren't any testing issues or anything like that. So she can get an assessment ahead of time because she may need one anyway, but that's not going to affect the plea. Okay,
thanks for letting me know. This is Mr. Lebo's case, so I'm not sure what him and Ms. Norman discussed as far as assessment, but that is in the notes for her to complete that.
Thank you. Ms. Norman, you also have a speeding ticket here from 2023 that is in show cause status. What's your intent regarding paying that ticket, ma'am?
Yes.
When do you plan to pay the ticket, ma'am?
I wanted to start paying it this week. I do get paid on Wednesday. I didn't know if I could pay it in portions. I know it was probably like over $100. I didn't know how the best way I could do that, or how, if I have a deadline or not.
1 second, I can tell you how much it is, and what you can do is you can come into the courthouse and make a payment or send it through the mail, but you can't pay online in portions.
Okay.
It's $180, ma'am.
Okay.
Do you need a payment plan where you can come in to pay it?
Yes, I can pay. I can pay most of it. I can pay 100 this week, and then I can pay the rest next week.
Okay, I won't put you on a payment plan. The next court date is not going to be until July 16th anyway, so you should have it paid off before then.
Okay. Yes.
Trial is adjourned to July 16th, 2024 at 9 a.m. Bond is continued. And your ticket will be moved to that same date. Okay.
Okay.
Thank you.
Thank you, Your Honor.
Have a good day.
Thank you. You too.
Bye-bye. We'll call the Tierra Anderson matters. Case number 23T00751 and 22W002690.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Mueller here on behalf of Tierra Anderson. Ms. Anderson, can you state your name, please?
Tierra Anderson.
Thank you. Good morning, Ms. Anderson.
Good morning, Your Honor.
Ms. Anderson is valid. I'm sure that was give us. And I don't know what's the situation with her insurance.
Yes, I do have insurance.
Yeah, I think that information was provided to me previously. So what we'll do in this matter is amend and add a count of the civil infraction for impeding traffic. She could admit responsibility to that, and we'll dismiss the 2 misdemeanor charges.
Thank you, Mr. Barnett. Ms. Anderson, Ms. Anderson does want to accept that offer. She is requesting to have 20 days to be able to pay off that ticket.
So, okay, I see. So she's going to admit to added count 3 of impeding traffic. Counts 1 and 2 dismiss. And 20 days to pay the other expired plate ticket.
It'll be paid by next Friday after this Friday. I believe that's the 21st.
So as to case number 23T00751, it's my understanding that you're going to be admitting responsibility to an impeding traffic for an offense that occurred on 1 second. You can put the documents on separate sides to confuse me. And then the other side is confused. Here it is. Okay. That occurred on October 21st, 2023 at the vicinity of US 12 bypass and Wyatt Road. Is that
Yes,
correct?
Yes, ma'am.
Thank you. Counts 1 and 2 are dismissed. The impeding traffic fine is $180. So can you pay that today or you need?
No, I can have that paid in full on the 21st, Friday after next.
So what we'll do is we'll just put them both on for July 9th. If you paid them up, then you don't have to be here, okay?
Okay. Bless you.
Thank you so much.
Boring.
Appreciate it. They'll both be on for 10 a.m. So as long as you're paid, then you don't have to see you, okay?
Okay, I appreciate it. Thank you.
It's so
Good day.
boring when the
You too.
defendants act normal. Bring me a soft set. Come on.
State of Michigan versus Cortez Davis, case number 24S00089.
To make this for the people.
Assistant Public Defender Allison Miller here on behalf of Cortez Davis. Mr. Davis, can you state your name, please?
Cortez Davis.
Thank you. Good morning, Mr. Davis. Mr.
Good morning. How you doing this morning?
I'm pretty good. Mr. Davis is here for a pretrial and a show cause.
Your Honor, as to the pretrial, we would be requesting an adjournment to
Nice
go
to
over
hear.
discovery together and decide how to resolve the case.
No objections to the adjournment. Mr. Davis, I don't know what happened with his PCC on his felony case. That was, I believe, last week. PIS isn't updated.
Exactly.
I haven't pulled it up in
I got
on
I got
base.
court. I got court on the 18th.
So it's set for preliminary examination on the 8th.
Huh?
I just said it was set for a preliminary examination next Tuesday, like you said, the 18th.
Yeah, yep, it's on the 18th. And in that case, most likely, just like my lawyer said, they have a picture of the person that it is, and the picture is not me. So
All right.
And Ms. Bucknell, also, just so you're aware, Mr. Davis previously had an embezzlement case with Speedway pending in this court set for bench trial. And it was dismissed at the time because we had lost contact with the store personnel. We have since recontacted them and they've appeared in this court for several hearings. So he was advised that that would be reauthorized once that contact was reestablished. But just so you know, that other case is out there as well.
All right. My
I
contact tells
haven't
me
seen that I got any information on that other case.
You're
looking
saying
for
that
Thomas
you reauthorized
Stryon.
it already?
No, I
Yeah, I
haven't yet.
can't. Oh,
I'm
You
just
haven't-
saying, I saw him on the docket today and remembered that that case had been previously dismissed.
So what you're saying is you plan to reauthorize it soon?
Yes.
Okay. I thought I called, but I haven't heard Mr. Barnett chime in, case number 23W002509.
Oh, I'm sorry. Paul Barnett on behalf of the township.
All right. In that case, it's a show cause anyway, but you're requesting an adjournment. What is his plan with respect to paying the parking ticket?
I could pay like $100 today.
All right. Can you tell me what the balance is?
Make yourself comfortable, top center there.
She took.
No, I was asking the reporter to give me the balance, please. 1 second. It's a total of $222. So if you pay $100 today, all right, we can start with that. Let's see. You're asking for an adjournment. I can give you the July 16th date,
Okay, yes, that works, Your Honor. Thank you.
July 16th, 2024 at 9 a.m. for both. So you should have that $100.
Okay.
Bond is continued. You're all set, sir. Have a good day. The device labeled Room Tech, could you please unmute your device and tell us your first and last name?
David Phelan,
I'm sorry, what's your name? David Phelan?
yes.
And there's, I think that's it. The court will call the matters of David Phelan, 18 FB 1685, 18 FB 1910, 24 W000697. And that's it.
Person, Deputy for the People.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of David Phelan.
Thank you. So please, state your name again.
David Phelan.
Mhm. With respect to the pretrials, what's your plan?
Yeah, I'm a little confused. I saw it in the docket for a pretrial, but it looked like he's planning this case. Is this really supposed to be on here for a review?
Yeah, I think, well, at least ticket number 18 FB 1685 is. Let me look at the other case.
And that's the one I'm appearing on.
Yeah, both of them are, Your Honor. He's been appearing for payments.
All right. Yeah, these are payment plans.
I was not able to get in touch with Mr. Phelan, but I did see the last payment on 1685 was on May 14th. So Mr. Phelan, where are you on your payments for these matters?
I just made one like about 3 or 4 days ago.
Yeah, you made one for June 7th, on June 7th.
Yeah. So the next one I was gonna make is like Friday.
What I'm gonna do is put him on a payment plan, and that way it won't be as confusing in him paying on separate cases. Cause he doesn't appear he has a payment plan. Well, he said he was gonna pay 200 every 2 weeks, but obviously that's not working. How much
Yeah, I
can
had
you,
lost the job.
how much can you pay per month, sir?
I was gonna try to do the 200 again, but I probably like 100 every Friday or something like that.
You wanna just stick with your 200 payment plan?
Yes, if not, I'll just tell them, man, that I'm not working like that or something and drop it down. But I still like this Friday, I'm gonna put 100 on it and then follow behind it the next Friday and put 100 on it.
Okay, all right. Tell them that's me. I'm the one you tell, sir. So,
Okay, yes, ma'am.
I'll bring you back here on August 20th to see how things are going.
Okay, ma'am.
Your Honor, it does appear that the township case, a DWLS case, is still open. That's 24W 697.
That's funny. Everything shows up backwards. That one is he stood mute. That one is a pretrial. So what do you want to do on that matter?
Unfortunately, Your Honor, I did not have information on that one. Can I get the, hold on, let me get the case number.
He's still suspended. 24W 000697. Thank you.
I guess I would ask for an adjournment on that one so that Mr. Phelan and I could talk.
Let
And
me
if he's
see,
still,
let me see what he needs to do.
okay. Thank you.
He's suspended out of 14A2, which is the city of Ipsy, for driving while licensed, suspended from a 2007 ticket. He's suspended out of 14A1 for a no proof of insurance ticket for a 2007 event. He's got a lot of suspensions. Another one for 14A2. He's suspended here. Suspended out of 15th district. Second suspension from here from being intoxicated from 2018. Another one for the same situation. Let's see if that's the same event. 1 second. 18 FB 1910. That's the one that's on the docket. Yeah, that's the same one. So if you pay another $200 on your ticket, your 1910 ticket, then you can pay the $45. As a matter of fact, you can pay $150 and the $45 reinstatement fee, and I'll allow that one to be taken off your record, okay?
Yes, ma'am.
And then, let's see here. Two more from 14B. I can only help you with the ones that are here. You want to get your license back, sir?
Yes.
There's some ticket IB 07002245. You have a pen to write this down, sir?
Just a second.
And Your Honor, while he's doing that, I don't see us appointed on this case. I don't know if Your Honor can look that up.
You may not be,
1910 says first.
well, I'm looking at 24000697.
No one shows us being appointed.
All right. All right, I'll do a referral. I don't have any referral.
Yeah, I got a pen.
All right. All right, maybe they're in here, maybe they're in this stuff. All right, sir, the ticket that you can pay, as long as it's just a reinstatement fee, you can pay on IB 07002245, which is a $45, it looks like just reinstatement fee. And then there's another one second. Oh, and then it's just the other operating while intoxicated. And so that one you need to pay $150 and you can then pay the $45 reinstatement fee. And then all you have left is two 14A2 cases, a 14A case and a 15th district court case. You'll have to contact them directly, but it looks like something you should be able to get taken care of. Okay?
Okay.
It might
Yeah.
take some time, but you can work on that. Okay? So you want me to give him some time to pay these, Ms. White?
Yes, Your Honor.
All right, and I'm referring this matter to the appointing authority as well, so that the PD's office can be appointed.
Thank you.
And I will see you back here, sir, on August 6th.
Okay.
You should have some time to work on those. So you should at least have the 14B matters taken care of by that
Sorry,
time.
sorry, Mindy, I
Okay.
banned you by accident.
Yes.
It was a complete accident. I'll figure it out and unban you.
Mhm. You're all set, sir. I see you back here on August 6th at 10 o'clock I'll do 9 o'clock a.m. for all of them. I'll see you at 9 a.m. on August 6th, okay?
Yes, ma'am.
Great, thank you. Take care of yourself, Mr. Phelan. Bye-bye.
Yep. Motherfucker, yeah.
Yeah, on the 1910, he can pay.
Just the 1910.
Yeah, the other one he just can buy his clearance.
Okay.
He doesn't owe us anything, I
Okay.
don't think.
I just have to note it in there so we don't.
Soft sit hunting. It's kind of like snipe hunting. Most of you probably don't know about a snipe hunt. But it's a tradition back in the day when I grew up. It's good times. I recommend it.
State of Michigan versus Chloe Clifton, 16-00931.
Rachel McDuffie for the people.
Good morning, Your Honor. Assistant Public Defender Donald Lee on behalf of Ms. Clifton. Ms. Clifton, could you state your name, ma'am?
Hi, I'm Miss Chloe Clifton,
Thank you. Good morning, Ms. Clifton.
Your Honor.
We're here for a pretrial today.
That's correct, Your Honor. We previously adjourned so that I could come up with an offer for Ms. Clifton, but I didn't know who was handling this case.
A lot
and
of
didn't
people have
hear
sent that to me.
from anyone about it. I can just place it on the record. Ms.
If someone gives me
I can dismiss
a
count one.
timestamp, I
She
might
can plead to count two.
do that right now.
Count two is the false info to a police officer. And with the
Upset.
deferred and now reporting probation, I would just ask that she do 24 hours of community service. And then the case could be dismissed afterwards.
Your Honor, should I have a brief breakout room with Ms. Clifton to discuss that offer?
Yes.
Thank you, Your Honor.
Pass that, man. Court will call the matters of John Wayne Russell, 22-00902, 21 W 003469 and 22 W 005866. We're here for two show causes and a pretrial.
Rachel McDuffie for the people.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of John Russell.
Sir, please state your name for us.
John Wayne Russell.
Thank you. Good morning.
Morning, Your Honor.
John Wayne.
I'm sorry, Your Honor, I'm just reading through Mr. Lebo's notes. Mr. Russell still is not valid. He would like an additional 60 days to get his fines paid. He was homeless at the last court date. He states that he now has a stable place to live and he is working. So we are asking for a final 45 to 60 day adjournment.
No objection.
Oops, it was a Mindy. Poor Mindy. I'm just messing
All right,
everything up.
Mr. John Wayne Russell, we'll see you back
fix
here on August 20th at 9 a.m. for all these matters.
Thank you, Your Honor.
You're welcome. Take care of yourself, sir, and I wish you the best in trying to get this resolved.
I'm going to do my best. Thank you so much.
Thank you.
Can one of my
I need to
mods do
see.
it?
I need to see
no.
progress, though.
Yes,
Okay?
ma'am. I
All right.
paid some on some of the tickets, and I will take care of this.
Okay. All
Thank
right.
you so
So,
much.
have a good day.
This is what I need you signing.
Bye-bye.
Bye-bye.
I'll take care of it. Okay, thank you. Yeah, I got it. Okay, thank you. Have a good day. You too.
Is this our man? I have no idea. I don't know what he looks like.
Did I sign in?
Mr. Sean, please mute your device.
Huh?
Please mute your device.
I did
Court
another
will call the
short
cases
video
of
last night.
Amal Kasham, case numbers 21S396659.
What, Trevor? What is so important right now?
Ma'am, what is going on in your household with all that noise in the background?
Okay.
Your Honor, I'm sorry, let me let you finish calling the cases. I was just going to say that Ms. Kasham is supposed to be in person today, but let me let you finish.
What is so important?
21W002620, 22W001931.
Rachel McDuffie for the people.
Paul Barnett on behalf of the township.
Ma'am, please state your name. Ma'am, please state your name.
I'm Al Kasham.
Thank you. I did say in person. Ms. Kasham, why are you not here?
I don't have any transportation and I'm all the way on the other side of Novi.
You don't get to just choose.
I know, but there was no other choice of I didn't have any other choice.
You know what happens when you don't show up to court?
No.
Bench warrant issues.
I know, but I'm trying to see if I can do it through Zoom.
I already told you that I wanted you to do it in person.
I understand, but there's no way of me getting there. I'm
Well,
requesting.
the police can help you to get here.
And Your Honor, I know I did this last
Bye-bye now.
time with Ms. Kasham's OWI case, which it looks like she has since been arraigned on. We have a new warrant request for, looks like uttering and publishing out of Ann Arbor. Offense date is April 12th, 2024. So Ms. Kasham will likely have a warrant issuing for that as well.
What is it for?
It's not authorized yet. Fraudulent checks, basically. So just.
Oh yeah, I had gone back to.
Don't.
Okay. I'm not on speaker to defend myself.
She's helping you, honey.
Ma'am, what she's trying to do is protect you from yourself. Anything you say can and will be used against you.
Okay.
Mr. Shell made any payments?
I haven't had any income in the past 3 months, Your Honor.
Did you sell any burritos?
Like,
Even one?
I tried, but honestly I couldn't because I haven't had a car. My license been moved. I haven't been getting to work lately and it's been a hassle.
That really, really sucks. I mean, really.
Mr. Sham, the only reason I'm not issuing a bench warrant this time is because these are for failure to pay.
Thank you, Your Honor.
August 6, 2024 at 10 a.m. I'm writing in person and bench warrant to issue if you don't show again for contempt.
Okay, so I have to be in person?
Yep.
What if I can't get a ride or transportation to court?
I just told you what happens if you don't.
What happened?
When you get off the call, review this conversation. I'm sure you can figure it out. Have a good day. Bye.
Okay, that was fun. It got worse. We haven't found our soft sit yet, but that was fun.
Need a translator. No, for nothing. Okay.
Oh no. I just want a soft sit in their glorious faux English. Yes, I got sent here by contact. Told that there may be a subset. I don't know if I should name the contact because they didn't say.
What we'll call the Richard Kennedy matters, case number 06S1306966A and B, as well as 10S00810.
Rich McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Richard Kennedy.
Please state your name, sir.
Rick Charles Kennedy.
Thank you. Mr. Kennedy is here for payment plan review.
Yes, Your Honor. Mr. Kennedy does look like he made a payment yesterday. He thought he was up to date on his payments, but we can't find one for May. You did have a receipt for that one, right, Mr. Kennedy?
Yeah, well, I use my Cash App. All I got is proof on my Cash App. I made the payment May the 15th.
So we don't know where that one was applied to, but I do see one on the 10th of June for $25 and one on April, but I don't see the one for May 15th in the system.
Does he have a case number that he was applying it to?
I can't remember. It was because I got 3 tickets I'm paying on, and I just pay up one is like $424. That's like a civil infraction, and I'm gonna have to pay that all at once. But the 2 driving on suspended, I've been switching back and forth, paying 25 on this one and 25 on that one. So, because I think it's one from 2006, and I want to say it was one from 2010 that I've been paying on back and forth, because both of those is like $375, and one is $350, and the other is $375, and then I got that civil infraction for $424. So I just missed.
All of that's correct. So I think you need to call out to the clerks and talk to them.
Okay.
We found it May 25th, made on 10 on the 10S ticket. It is there.
Okay.
All right. Defendant is current. I'll see you back here if necessary, sir, on September 10th, 2024 at 10 a.m. If you are paying like you said you are, you don't need to be here, okay?
Thank you, Your Honor.
All right, have a good day, sir.
All right.
I'm sorry, Your Honor. Can I get that date again?
September 10th at
September
10.
10th.
All right, we don't have anything that's ready to go.
Clifton is ready, I believe.
That is correct, Your Honor.
Thank you.
Probably putting the subset at the end of the call because, it's always a hassle. Dick is back.
State of Michigan versus Chloe Clifton, recall 16S00931.
Rachel McDuffie for the people.
Assistant Public Defender Davi Lebo for Ms. Clifton. Ms. Clifton, could you state your name, ma'am? Ms. Clifton, could you state your name, ma'am?
1 second, she may have signed out and she's signing back in. No, that's not her. She's not here. So I don't know, she signed out. You might want to call your client back.
Yes, I will, Your Honors. Thank you.
I'll pass that again. There's a device labeled iPhone that is moving around a lot in a warehouse. Can you please unmute your device and tell us where you are? I mean, what your name is?
Michael Carter.
No, you're not in a warehouse, but thank you.
Oh, I'm sorry.
It's okay. Please unmute the device. You're walking in a warehouse. Looks like a lady with glasses.
Warehouse, big dummy. Are you in a warehouse? If you're not in a warehouse.
Can you hear me?
Yes. What is your name, please?
Tracy Reed.
Thank you, Ms. Reed. Is David? Yeah. Is the device labeled David? David, yeah.
Yes.
Thank you very much.
Yes. Good morning, Your Honor.
We're just trying to figure out who you were so we can get your case put into order. You can remute yourself, sir.
Okay.
Thank you. Zoom user with the photo. Okay, this guy down here. There's a gentleman with a photo, with a, I don't know, it looks like a khaki looking shirt on. Could you please unmute your device? You say Zoom user, and it only shows your photo. Please unmute, tell us who you are, otherwise we can't call your case. You should be labeled when you come into the courtroom, otherwise we don't know who you are. Okay, he's not answering. I'm gonna call Chloe Clifton.
Is
What's
it
your-
John Alcala?
I guess it is, if that's your name. We don't know what your name is, sir.
All
right. Are
was
you
it
John?
me?
Yes, it's you.
Oh, okay. It was a white shirt, so you threw me off when you said khaki.
Well, it doesn't quite look white on here, but
Oh, I got you. I'm sorry.
all right. We'll put you on a list of cases to be called, sir. Okay.
Okay, thank you.
Thank you. All right, the court will recall State of Michigan. Please mute your device, Ms. Reed. The court will recall the case of the State of Michigan versus Chloe Clifton, case number 600.
Rachel McDuffie for the people.
Assistant Public Defender Davi Lebo for Ms. Clifton. Ms. Clifton, could you state your name, ma'am?
Chloe Clifton.
Thank you. All right. What did you decide about the offer?
Yes, Your Honor. Ms. Clifton will be entering a no contest plea to count 2 with a sentencing agreement to, my understanding is immediate sentencing to a deferred sentence of 24 hours of community service.
Why are we doing no contest?
The event occurred in 2016 and Ms. Clifton lacks memory.
Ms. McDuffie?
No objection. It was quite some time ago, Your Honor.
Did anyone send me the report?
I did, Your Honor.
It looks like it went to Ms. Ball. I don't think it, I can hit forward and send it directly to you, Your Honor.
Ms. Ball is sending it to me.
Okay.
It'll take it a while for it to download still. Mr. Levi, please make sure you just CC the prosecutor and include me on it. It takes much longer the other way.
Yes,
All
Your
right.
Honor.
It is my understanding you're gonna be pleading to count 2, which is giving false info to a police officer. And count 1 is going to be dismissed. You'd be on the deferred program to the prosecutor's office. And you would, have to complete, did you say 20 hours of community service?
24, Your Honor.
24 hours of community service, and then this matter would be dismissed. Is that your understanding of the agreement?
Yes.
And that's what you want to do?
Yes.
All right, this is a misdemeanor carrying a maximum penalty of up to 90 days and or $100 fine, plus court costs. Do you understand that, ma'am?
Yes, Your Honor.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You may lower your hand. I'm gonna go over some rights that you have that you're gonna be giving up by entering into this plea. Please stop me if you have any questions, or if you feel like you need to speak with your attorney again, okay?
Okay.
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. And you have the right to be a witness for yourself, or you could choose to remain silent. If you do choose to remain silent, the prosecutor cannot comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, Your Honor.
You understand you're gonna be giving up all those rights and you're not gonna be having a trial of any sort?
Yes, Your Honor.
You also understand that if you're on probation, parole, or bond, you could be in violation of that probation, parole, or bond if if you were on it on, well, you wouldn't be on it anymore anyway, April 1st of 2016.
Yes, Your Honor.
And there is no automatic right to appeal the decision you're making today. So in all likelihood, this decision is gonna stick with you. And the reason I keep looking to the side is I'm trying to pull your police report up. So I want you to understand what I'm doing. I am paying attention to you, okay? All right. You understand that there's no automatic right to appeal the decision?
Yes, Your Honor.
All right. And then in addition to that, ma'am, if you're not a US citizen, you could have immigration consequences. Are you a US citizen?
I am.
All right. And then, to the charge of, gave false information to a police officer, how do you plead?
No contest.
And the basis for that is that she has lack of recollection since it was in 2016.
That is correct, Your Honor.
All right, I will accept that as a proper basis for a no contest plea. Ma'am, you understand that, what no contest means?
Yes.
All right, you're not gonna say you did it, you're not gonna say you didn't do it, but the court is going to enter a plea like you're guilty, you understand?
Yes, Your Honor.
And then, anyone promise you anything other than what we place on the record to get you to plead?
No, ma'am.
Anyone threaten you in any way, shape, or form?
No.
Thank you. I'm gonna review case report number 160024456 with a date of incident of April 1st, 2016 at the location of Ecorse Road and Ford Boulevard here in Ypsilanti Township. Do the attorney stipulate to my use of this report to determine the factual basis?
Defense still stipulates, Your Honor, and I would ask the court to look at page 8, which I believe is the relevant portion.
Thank you.
People stipulate as well.
Thank you.
We may be on another stream to nowhere.
It's like fourth paragraph.
All right, thank you.
A lot there. Yeah.
All right, on this date and time, a vehicle was stopped at, Miss Clifton. At that time, she was not Miss Clifton, she was Miss Zogier, I guess is how you pronounce it. And she had told Deputy Webb that her name was Genesis Kyra Fountain with a date of birth that she had given at the same time. Once they pulled her out of the vehicle or she was exiting the vehicle, they searched her purse and discovered her ID with her real name on it. I do find that there's a factual basis for the plea. She also told them that ID, the proper ID, was also fake. I do find that there's a proper basis for the plea that's been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
People are satisfied.
Defense is likewise satisfied, Your Honor.
She went full
Thank you.
McLovin.
All right.
If you're gonna make up a name, don't have it crazy as hell.
As to sentencing, are we doing immediate sentencing?
No objection.
All right, thank you.
And that is what the defense would be requesting, Your Honor.
Anything you want to say on behalf of your client?
No, Your Honor.
Ms. McDuffie, anything from you?
Nothing from the people, Your Honor.
I could do it.
Anything you want to say before sentencing, ma'am? Ms. Clifton?
Oh, no, Your Honor.
All right. All right. Fines and costs in this case for a total of $325, 24 hours of community service. How long will you need to get those things done, ma'am?
I would say maybe a week for the community service. I'm gonna need some time for the money.
Okay, why don't we do a review in 3 months?
Okay.
September 10th, 2024 at 10 o'clock a.m. Hopefully you can have all that taken care of by then, and then this case can just be dismissed, okay?
Thank you, Your Honor.
You're welcome. Have a
And
good
Your
day.
Your Honor, I know Ms. Clifton is not on traditional probation, but should she still reach out to them just to get the more information about community service and what kind of documentation we usually look for?
That is true. Please reach out to them. I presume she had someone in mind, since she said she could get it done in a week. But you can reach out to probation. Do you have a pen? I'm gonna give you the phone number now. Anybody else on the call that may need to reach out to probation should write this down at this time. 734-483-7336.
Thank you.
Thank you. Have a good day. Counts 1 and 2. Counts 1 is dismissed.
Have a good day as well, Your Honor.
Bye-bye. Before we call the cases for Michael Carter, case number 16W00566, 16W011496, 20S3806190.
Paul Barnett on behalf of the township.
Mr. Michael Carter, please state your name.
Michael Andrew Carter.
Thank you.
Thank you.
Who is handling the says Simpson right on there on 06 at the B ticket. Oh, I'm sorry, nobody from PD's office. All right, we're here today for payment. Mr. Carter failed to appear on April 2nd, and it was scheduled for contempt proceeding today.
I had a question about that. I thought if I had paid the 100, I wasn't gonna have court. That's what the miscommunication. I ended up paying like what I had for my payment, and I thought you told me like I didn't have to go to the next court date if I paid it. So that's what it was kind of like. I was kind of confused on.
That was back in August.
No, I had paid another 100 after the court date over the on the website.
You paid in February?
Yeah, I paid like $105 on the website. I'm let me see if I can get my my fiance can find what's the name number. 1 second.
just contempt for non-payment. I got excited. I thought this guy would have attitude, but he's fairly reasonable so far.
She looking for the what's the name number?
All right. Well, I'll wait to hear back about that part, but your payment plan is 100 per month, so you're supposed to be paying 100 per month, sir.
Yeah.
So,
I had a little trouble for sure.
are you gonna be able to pay timely?
Yeah, I can pay timely if we kind of cut it down to maybe like 50 or 75, because I was working like a little side job. Now I'm back with my son, as you probably hear in the background crying.
No, actually, I couldn't,
Okay.
but, all right, so you need to change your payment plan.
Yes, ma'am, please.
What are you asking for? Because you've given me.
At least just like $50 to $75.
I need an exact number, sir.
$50.
Okay.
If the quarter honor.
All right. So we had set you up to pay 100. Let's see. I think I might know what happened. All of these are not on the same payment plan. So you're supposed to be paying 100 per month on one of them on the 8th of each month. So let's just do, are you still able to pay on the 8th of the month?
Yes, I am.
All right, so we're gonna do $50 on the 8th of each month. And I'll put the same payment plan on each one of them.
Okay. So the 50 the 50 will go to both of, like it was split between both of them.
What they do is they just pay off one before they go to the next.
Okay.
So it shows that you are current when you make one payment.
Okay.
And you weren't set up like that, so it may have just been missed when we looked at it. All right. I'll see you back here on September 10th, 2024 at 10 a.m. If you are making those payments, you make that payment, you should be fine. You might want to check in.
Okay. I'm gonna make them, and I'm still just gonna come in and see what's going on. It's all right.
Well, you're here today, so you wouldn't get a bench warrant the next time. Okay.
Okay.
It would just be a show cause again, another contempt proceeding.
Okay.
You don't have a history of failing to appear. So.
Okay. Appreciate you, Your Honor.
You're welcome. Have a good day, sir.
You also.
All right, bye-bye.
Bye-bye.
State of Michigan versus Larry Hinton, case number 19-00531.
Tracy Deputy for the people.
Assistant Public Defender Davi Lebo for Larry Hinton. Mr. Hinton, could you state your name, please?
Larry Hinton.
Hello, Mr. Hinton. Last
hello.
time I saw you was March 12th. Mr. Hinton was current. Where are we right now, Mr. Lebo?
Your Honor, Mr. Hinton recently lost his job. He does have a new job now, but he did have to stop making payments while he was unemployed. He would like to resume his $30 a month payment plan.
All right. September 10th, 2024 at 10 a.m. Mr. Hinton, I'm sure we'll get back on track like he always was. Have a good day, Mr. Hinton.
Thank you. You too.
Bye-bye.
Thank you.
The court will call the Rennell Reed matters 22S00737. Okay, 1 second. That's the wrong one. That's okay. Here you go.
Thank you.
All right, the court will call the Tracy Reed matter. Case number 17 FB 1828, 17T 00618, 20W 004128R, and 22W 004215. We're here for show causes on all of these matters.
Certainly, Deputy for the people.
Paul Barnett on behalf of the township.
Ms. Reed, please state your name. Ms. Tracy Reed, please unmute your device and state your name. All right, she is no longer here. The court will, is she current? Can anyone tell me that so I don't have to recall this case?
I'm checking it out.
Your Honor, I'm representing Renell Reed. I don't,
No, I called Tracy Reed.
okay.
Your Honor, I don't see anything, I don't see anything on the case ending in 1828.
No payments have been made.
Guatemala in the house. I love it. I'm not too far. Chilling in CDMX.
Failed to appear, failed to pay, July 16th, 2024. At 10 a.m. for all these cases. I'm not recalling it. The court will call the matter Ypsilanti Township versus David Yap, case number 22T00731.
Paul Barnett on behalf of the township.
Good morning,
Love
Your Honor.
Thailand.
Good morning. Please state your name.
David Yap.
All right. Mr. Yap, it looks like you're doing very well now. I'm very happy to hear that, sir.
Yeah, thank you, Your Honor. I'm attending 5 AA meetings a week and yeah.
Good. Anything from anybody else on this particular matter?
Nothing from the township, Your Honor.
Okay. All right, sir, we're going to continue you on your probation. You need to continue being engaged with your outpatient personal therapy and your maintaining your sobriety. I'm very proud of how far you've come, Mr. Yap. So,
Thank you, Your Honor.
we will see you back here in 60 days to make sure things are still going well. That'll be on August the 20th at 10 o'clock a.m., okay?
Delgina looks
Thank you, Your Honor.
like she's got
Is there
potential,
anything you wanted to say, sir?
but I could see her being reasonable as well.
No, ma'am.
All right, see you then.
Tough to say.
Thank you. Have a good day.
You too. We'll call the matters of Renell Reed, case numbers 22S00737, 12Ws 203910R, and 22S00737.
Certainly, Deputy.
Paul Barnett on behalf of the township.
Attorney Deborah Ford on behalf of Renell Reed.
And Assistant Public Defender Daffy Leap on behalf of Mr. Reed in the 737 matter, unless Ms. Ford is on that matter.
Yes. I just retained in.
Thank you.
Mhm.
And Mr. Reed's other two cases, which are for show cause. Other one case is which is for show cause, and he's here for a bond violation also in the 737 case. Mr. Reed, please state your name.
Renell Reed.
Thank you.
Your Honor, I'll ask if we can approach quickly with counsel.
Thank you. You may.
I'm sorry, would you say that again, please?
We're approaching.
Okay. Thank you.
Maybe we get a breakout room. I've seen it happen on YouTube. That's not good. That's supposed to be a private conversation. All right, should I give up on this and do whatever the attorney held in contempt in the, I don't know, was it Young Thug trial?
Okay, Mr. Steele, would you take the podium, please, sir? All right.
All right, where's the good part? Somebody give me I'm not doing this whole
All right.
hearing.
Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again. And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6. I know what the rule says, but here's the thing. Well, let me just. You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. I understand. I don't want to be held in contempt. And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened. Sir, that's a whole separate issue. And that's why ex parte conversations are recorded. Why would it be ex parte? You're acting like it's ex parte under seal. It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation. I've never asked this honorable court or any court to meet with me and a witness. Sir, you're straying off the issue. I'm not. The issue is how did you get this information? I understand the issue. I promise you I understand it. But what I'm trying to ask you is if you look at comment 5, this is how I understand the law. You cannot you can't violate something and then use privilege. Okay? I'm not violating anything. Okay, but that's why I'm saying, how did you get information? But
just listen to what I'm trying to tell you.
Okay,
you're
but
saying,
see,
you're threatening me with
the
contempt. Just
privilege
listen
would
to this.
occur, the privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it, but if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, or you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm gonna hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have
may
an
be
idea
wrong.
how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not
Sir,
going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can
okay,
talk.
Well, then you'll be in custody until then, because because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information, or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have a.
When I got this information,
I'm not going to have any further conversation with you about this. I want to know. The question still remains. I want to know who gave you the information.
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your. I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not when that is not the case when somebody discloses information in a ex parte conversation that the one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
that leads to be told. But
right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
and I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right on the
Just stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1,
because you've already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Love.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from this law.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition. He asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
I have thoughts. You're not going to like them, but I have them.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has 2 attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right.
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position I also do not.
Well,
believe that-
I asked him, so I didn't ask you.
Yeah.
So, but, I'll leave it at that. Okay?
Impressive.
What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the same.
All right,
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Mark Huey.
okay.
We are also adopting all the arguments that have been made.
All right, sir.
Still by Attorney Pete Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also, Your Honor, we were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an explanation that was had, that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon Again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. T. Williams? All right, thank you, madam. Motion's denied. Mr. Gardner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. Once he's clears the area, we'll go ahead and get started.
If by that, the court means we'll get started and resume the trial, Your Honor.
Yeah, we're gonna continue. I'm not caught nothing.
I'm not going to participate in the trial without the Steele and without.
You don't have that luxury at this point in time, sir. You don't. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue, we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No.
Mr. Williams' rights.
It's not, sir. Sir.
Is not.
That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of.
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And
Wow. Well, there you have it. All right. So that was my first time through. Here's why you're not going to like it. I don't know who's right or wrong, but I have serious thoughts about this. I don't know who's right or wrong because I don't practice criminal law. I don't practice criminal law in Georgia, and there may be some provision for this. I also have not been watching this trial, so I'm not familiar with all of the context of this, and I'm not sure what's true and what's not. All right, there's my disclaimer. That's why you're not going to like it. I don't know who's right or wrong, but I will tell you this. It looks sleazy as hell to me. Maybe that's allowed, but I've never seen anything like it. I can't imagine an ex parte meeting with a witness mid-trial. I can't imagine it. I can't imagine it. I don't think the attorneys were out of line if that's what's gone on. It gets back to facts that I'm not sure of. But if that's what's going on, that sounds insane to me. Again, there are two things. Maybe that's allowed. Maybe there's specific provision that's allowed in Georgia or something like that. It has a horrible appearance of impropriety. I'm going to have a meeting with the prosecutor and a witness and I may even have that wrong. So that's why I don't want to be too high in my soapbox here. But as is my understanding, and that's the first time I didn't watch any of this before. I watched this because we couldn't find the subset, so I flipped to the stream. So I had no doing this. But in over 25 years of litigating, I've never seen an ex parte conversation with an attorney and or witness mid-trial. Never once. And I was a prosecutor many, many moons ago. It's been civil since then, but I can't even imagine it. In the Daily Center, where I practice the most, there's a separate bank of elevators for the judges so they don't have to get on the same elevator with the attorneys for this reason. That's how serious it is. In other courthouses, when occasionally you do get on an elevator with the judge, you may know the judge. You may know the judge's children, where they go to college, or everything else, and you will ignore each other and not say a word for the appearance of impropriety. An ex parte meeting mid-trial that, according to these defense attorneys, they weren't aware of, is absolutely insane to me. But I have to temper that with there may be things that I don't know, because I'm literally getting all my facts from the video I just observed. That's my thought. I looked at that and thought, wow. Now I don't know if so the judge is saying, well, you have to divulge your source because we were having. The way I see this is you have to divulge your source to me of the information. So they have a conversation. That conversation is leaked to defense counsel. And the judge is saying, you have to disclose your source. Basically, you have to tell me how you observed me having an ex parte meeting. So the threshold issue is it okay for you to have an ex parte meeting with a witness and the prosecutor? It doesn't feel like that's okay. But again, I don't know. Maybe that's allowed. Presuming that's allowed, then we're into presuming that's allowed. Let's say he can say, "Oh, okay, there's some code provision. Okay, mid-trial, you can do it for this reason, whatever." Let's say you could do that. Now he finds out about it. he's got a privilege issue. That's privileged information he can't divulge. I thought that the defense attorneys were very respectful. It got a little snippy with the judge, but when you're going to hold an attorney in contempt of court and remove him mid-trial from representing his client, if ever there's a time to get snippy with the judge, that's it. Now we're making records. The judge, you know, the way this works, it's not like the judge is in some Lord High Almighty. The judge is supposed to be a neutral, and they have constraints as well. Attorneys know this, but on the outside, everyone thinks sort of like the judge is the king and in charge. They sort of run the show in the sense that they're applying the procedures and stuff. But it's sort of a co-equal thing. The attorneys are officers of the court, and they have clients, and they have ethical obligations, and they can't bend those for the judge. If the judge is wrong, then so the attorney could say, okay, yeah, Joe Schmo sent that to me, and then he can get rung up on an ethics violation. We're not just worried about the judge. We have other constraints as attorneys. We're worried about our client primarily. If they're having an ex parte and they aren't supposed to, I would say the same thing. Lock me up, judge. Lock me up. If you think that I'm not telling you anything. And I wouldn't say I'm not proceeding, but I would make a big record about this is, they did that. I would certainly make a motion for a mistrial, and I would certainly, I perceive it that, but I would certainly make a motion for mistrial. His comments on the way out, I think, were appropriate. He said, I want to make a motion for a mistrial based upon this ex parte communication that I wasn't aware of. But then as he's being pulled out, I said, hey, can I say one more thing? And he comes up and says, okay, now I want to make a motion for mistrial based on you denying my client their right to counsel. That's an additional different basis, and you want to make a record of it. I was also very impressed with his co-counsel who stood up there. I thought every defense attorney in there comported themselves well. And it was impressive. All of them just said, you know, you can hold him in contempt all you like, but I have the exact same position he does, Judge. So are you going to hold Saul in contempt? How are we doing this? So that's how it is. I don't know. There are two issues where I think it's hard to justify that contempt. One is, I don't know if it's proper that they had that meeting. First of all, I don't know they had the meeting. If they did have the meeting, I don't know that it's proper, but it doesn't seem like it to me. That is way too cozy. Oh yeah, I'll have a meeting with one side and not the other. I mean, that's insane. I have never done that. I've never done that mid-trial. I've never done it during the pendency of a case. Well, I shouldn't say that. There's one. Okay, I'll give another example to show how serious we are about this stuff. Sometimes you'll be going along, and you'll say, there's some issues, and we want to do what's called a pre-trial, where the judge will listen to the facts and say, all right, and try to settle the case. You can do it with the sitting judge, but oftentimes I would never do that with the trial judge. I would do it with the motion judge, or they'll send it to another judge just for the pretrial. Because precisely for the reason that you're going to end up having ex parte communication. When you have a pretrial like that, the judge will first meet with one side, ex parte, then meet with the other side, ex parte. But that's a different ball of wax. Everybody's agreed to it, knows what's going on. That is not what we're talking about. We're talking about they say assuming what the defense attorneys are saying is true, they say show up at 9:00. We don't start till 11 because he's in chambers with one of the parties. That's insane to me. That is absolutely insane. So there you have it. This was a weird stream. I looked for subs, I didn't find them, but I did find I did find a couple fun appearances, and then we went here, and then because a lot of people had requested this. I probably should have stopped the stream and done a different one. Maybe I'll split them up because they're just totally separate. So I don't know. I don't know. My gut feeling is I would lose my freaking mind if I was mid-trial and I find out that the judge is having a conversation with the other side. I would lose my, I've just never seen anything like it. It doesn't mean it's wrong. Possibly maybe there's a procedure where it's like, okay, under these circumstances, well, we can have ex parte things and people get noticed, and I don't know. Maybe this exists, but it strikes me as odd in that I've been doing this for a while and I've never seen it. In a different state, in a different context. I don't know everything. But my gut says that's not good. It's contrary to the whole foundation of how we do this. We have adversarial parties and a neutral. And there's so much precaution taken for this sort of thing to not occur. It's strange to me that it did, and that the judge's reaction is, well, how'd you find out about it? That's my take. All right, I'll close this thing down. Did the subset show up in Judge Simpson's room? Oh, he's in there now. Well, let's see what we can do.
That complaint alleges count 1 plea and eluding third degree. As long as you didn't see any issues with it. I think I know what's going on. I have a copy of the information.
This is definitely an all over the place stream. It's a lot of talk with Mike special.
As long as you didn't see any issues with the charge, the date, location, and then.
Yeah, she's all it's like 2 weeks everything. No, just tell them. It's just, this is not how it is. Did you close it like I said? Yeah. Oh, I have to. And I'm not.
I want to know why you got this.
Okay, all right. It's a winner. Yeah, okay.
That's the one asking.
Well, that's him.
Why ain't this been dropped yet?
I didn't know the best place to put it because I'm doing this on the fly.
Okay. Yeah, that's what I told.
Fourteen-day district court for County of Washington, State of Michigan, is now back to the honorable day session.
You may be seated. Court does call the case People versus Thomas Stein. Your name, sir?
Thomas Stein and National. So
This is date and time set for preliminary examination. My understanding is you wish to represent yourself.
appropriate persona, yeah.
Public defender is hereby relieved of any obligation in this case. Prepare an order for my signature, please, Mr. Odell. Thank you. All right. Court would further advise you, sir, that you are before the court on a 3-count complaint. That complaint alleges count 1, fleeing and eluding 3rd degree, which is a felony punishable by up to 5 years incarceration, $1,000 fine plus court costs. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Consecutive sentencing may be imposed if it occurred in a place of confinement. Count 3 is operating while licensed, suspended, denied, and or revoked. That's a misdemeanor charge punishable by up to 93 days, $500 fine plus court costs. You have elected to represent yourself in this matter. The court would first advise you that sometimes might be unwise to do so. The court will hold you to the same standard that I would hold a licensed attorney in conducting these proceedings. That is in reference to the Michigan Rules of Evidence and in the rules of procedure of the court. The court further would advise you that if at any time you wish to be represented by counsel, you would just need to let the court know, and the court will make sure that you are afforded counsel. Have you heard everything that I have said, sir?
So we're ignoring the fact that, as I've stated on the record previously, I'm not that artificial entity you have in that case file. And we're ignoring the fact that I challenged jurisdiction previously. I've still not seen anything that says you do have jurisdiction over me and over being able to charge you with this.
You can have a seat. I will assume that you heard what I had to say, and we'll proceed with the preliminary examination. You can have a seat right there.
Your Honor, before we begin, I just want to advise the court and that should be established on the record is the people's intention to add a count of felony firearm in violation of MCL 752, which is a maximum penalty of 4 years and or a $2,000 fine. That would be an amended count 4. And it's also people's intention, should the proofs bear this out, at exam to add a count of possession of a firearm, commission of a felony under MCL 750.227B with respect to both the proposed amended count of felony firearm and the existing count 2, assaulting, resisting, obstructing a police officer. So this defendant is aware the penalty on that offense is period of imprisonment for 2 years. Imprisonment prescribed by this section pursuant to MCL 750.227B sub 3
is immediately preceding the imposition of any other sentence.
Yes, sir. And then it cannot be, there is no probation or parole time to that time. It has to be, sir. You know, with that being said, people are ready to proceed on, sir.
Sir, understanding that there are those additional charges which may be added, do you wish to be represented by counsel? You wish to proceed as you are now? You may proceed, counsel.
At this time, people,
Sir,
Sergeant Hope, please.
please come forward, be sworn.
When you take a seat, raise your right hand. Do you solemnly swear in front of the testimony you about to give the truth? The truth is what you got? Yes, sir, I do. Go ahead, have a seat. Take a spell your first and last name to the record, please.
Oh, good times.
And quiet.
for hearing.
Thank you. Good morning, sir. What is your occupation? And would that be for Washington County Sheriff's Office?
Yes, sir.
And sir, were you working in that capacity on January 31st, 2024?
Yes, sir.
Was that in the city of Ann Arbor?
City of Ypsilanti Township.
City of Ypsilanti Township, thank you. And what were you doing at that time when you were working as a sergeant for the sheriff's office?
Supervisor for road control. And for road control and responding to calls as well.
And were you investigating anything in particular on that date?
Yes, I was dispatched to a potential domestic violence incident that was occurring in a motor vehicle.
And was the victim of that possible domestic incident known to you?
Yes.
Is this someone who'd been a victim in past incidents?
Yes, domestic violence incident.
Did you have a concern for that person's safety?
Yes.
In an effort to locate that victim, what steps did you take?
I was able to check through our internal systems and find an address for that victim. I didn't locate the vehicle or the person. Actually, I was dispatched. I went to the location of the residence to try to follow up and see if she's there.
Were you able to identify anyone at the residence?
No, nobody answered the door. There was a car in the drive that was registered to her, so I went to the proper house. But still no answer to the door.
Did you take any additional action in an attempt to locate a possible domestic violence victim at that time?
I got a hold of dispatch on the radio and I asked dispatch to run a all vehicle search to the victim.
Did dispatch provide you with any information regarding an additional vehicle tied to that victim?
Yeah, they indicated that one of the vehicles that was registered to the victim was a Buick vehicle with no license plate attached.
And when you received that information, what did you do?
When I received the information, I was stationed at City facing northbound on roadway, and I my here on the driver's side. It was a van, and as it went past, it kind of slowed down a little bit. Proceeded to pass through, and ended up being a vehicle plate.
And this was a vehicle description you had just received relating to the victim you're attempting to locate?
Yes.
When you saw that, when you made that observation, what did you do in response?
I asked dispatch to confirm if it was a van or a sedan over the radio. I didn't get a response, so I had to make a decision at that point.
And what did you do? What decision did you make at that point?
The vehicle had no plate on it. It had a civil infraction violation, and due to the nature of what I was investigating, I wanted to stop the car for investigative reasons, so I initiated a traffic stop.
Okay. And when you were observing the vehicle, did you see if there was a temporary plate or any other kind of plate displayed?
Yeah, I tried to look, but I didn't see it.
At the time of this stop, were you wearing your body worn camera?
Yes, I was.
And did you upload a copy of that and provide it to the prosecutor's office?
Yes.
Did you review that footage?
I have.
Is it a fair, accurate, and complete depiction of the events of that day?
It is.
And at this time, people would move for admission of the badge cam footage from this officer as People's Exhibit 1.
Any objection or what regarding that, sir?
Yeah, I'd like to adjourn to be able to review this, and I haven't had a chance to look at this evidence.
And I believe that the public defender provided our office with proof that the evidence has been turned over to this defendant. This is a discovery media receipt for this individual from the Office of the Public Defender.
That I have the discovery media receipt, and that was provided, but he's indicating he didn't see it. Is that correct?
They also turned over USB flash drive. That's not what we have a chance to.
Oh, so he did get it.
Also, I have a flash drive, I put mine in the scan. I haven't had a chance to look at that, I have that brought to me as well.
John, I'll defer to the court on the point.
Well, in regard to the discovery, Mr. Gaddy, where, do you know where Mr. Odetella is? Can somebody,
Judge Burke's, I can see.
can you see if you got Mr. Odetella? I'd like to know what was turned over to the defendant. He's indicating he hasn't, what you're about to show.
Fair enough, Your Honor. Thank you, Your Honor. May I flesh out some of the testimony not related to the video directly? While we're
Go ahead. That's fine.
Sir, at the time that you came into contact with the defendant's vehicle, or this unlicensed Buick rather, that you've testified about, what kind of a vehicle were you in? Okay. And what kind of clothing were you wearing at the time? So both your vehicle and the items of clothing you were wearing clearly identified you as a member of law enforcement? Yes. And to effectuate a traffic stop in this case, did you activate your lights and siren?
I first initiated my lights, was going to try to stop and did the stop search my siren, just to make sure I can see.
I'll stop at this point, Ron.
All right, very good. Mr. Odetella, I think the last time that we were here, there was discovery given to Mr. Siren. He has indicated just now that a video was not turned over to him.
We have turned over all videos, I provided him with the entirety of all media discovery guide.
Understood. So then the question becomes, Mr. Siren, you just haven't been able to review it, is what you're. All right, so here's what we're gonna do. I'm gonna, unless there's additional questions that don't have to do with that, but I'm concerned about even going forward at this point. So I'm gonna stop the proceedings right here. I will adjourn this out to my next date at having started before me, which is July 9th, 2024 at 11 a.m. What I would like to see, and we'll arrange it so that this defendant have access to be able to view that video. He'll make a choice as to whether or not he wishes to review it or not, but at least I will give him access or give him time in which to review that video. All right, this matter is adjourned. Thank you.
Thank you, Your Honor.
Well, there you have it. We spent all morning chasing the subset, and then that happens, which is understandable. We've been going back and forth with counsel. The discovery was turned over to the defense attorney. If he would have cooperated with the defense attorney, he would have seen it. The body cam footage is going to show that he doesn't have a tag, I'm guessing, but Judge Simpson did the right thing. He's saying I'm in jail and they gave me a thumb drive, but he probably doesn't have access to view it. None of it matters, but why give him a basis for appeal on this? So there you go. We'll go and play the thing to you, and that we'll come back because that evidence is definitive. So he's, fine. We'll set this over for a date. You take a look at it, and we'll all come back, and then we'll play the video, and that'll be that. Breaking verdict in for Hunter. I'm not familiar with this case, but I'd like to announce that there's a verdict in for Hunter. I'd go there, except I don't know that case at all. Everyone's all excited about it, but I'm not familiar with the case. I think I've provided enough commentary on cases I'm not familiar with for the day. There you have it. All right. Well, that was a wild stream. It was all over the board. I don't know what I'll do. I might chop it up. I might just leave it the way it is. I don't know. I don't know. Thank y'all for coming out. I appreciate it. I will see you all soon. Oh, wait. No. There's other thing. I missed this. I want to do a couple of the super chats because I think I was mid rant. And I missed these super chats. I want to put them up. Why couldn't you tell how we found this out? Attorney-client privilege. We have constraints on us. We can't just say whatever we want, however we want. Yeah, there's an attorney-client privilege. You'd have to get your client to waive the privilege. That's his argument, and I think I thought it was fairly strong. Again, I would need to know more facts, but that's the reason for it. Who's Ashley Merchant? She's someone who shows up later. You'll get more details if you pull up that clip. It's epic. All right, maybe if I see the Ashley Merchant stuff, that'll add to my understanding. Yeah, I thought the soft sit for all the world. He wanted to be stupid. I've seen him get smacked down 2 or 3 times already. This one. He's going around collecting bench slaps all over Washtenaw County. And he was raring to do it again. And the judge was willing because he dismissed the counsel. They've been back and forth on several appearances. All right, fine. You're representing yourself. Let's proceed. And then he says, yeah, then he says he didn't see the thing. So you want to make sure the guy sees the video before he proceeds. That's fine. But he was winding up to say some really stupid things. Well, I mean, he did in the few chances he got. It could have been fun, but that'll probably be fun in July. All right. There you go. Thank y'all for coming out. I'll see y'all soon.